So, Mr. Butterfield, have you and Ms. Felder Gates had an opportunity to discuss your motion to dismiss?
Actually, not, Judge. I filed it in December, and I didn't. I don't think they filed a written response. So, in part of my motion, I thought the law was so clear. I asked that it be ruled on, even without a hearing. But if we needed one, let's have it. But I don't think we got a chance to talk about it. I can ask her right now, does she oppose the motion? And then if she doesn't, then it could be granted. So I think that's the first question we can ask.
Well,
Sure.
Mr. Butterfield, let me do the bus driving.
Oh, yes, sir.
I call myself as a judge. I'm a bus driver. I pick people up and drop them off at particular points. So, Ms. Felder Gates, have you had an opportunity to review the motion?
I have had an opportunity to review the motion, Your Honor, and I do oppose it.
Okay. Mr. Butterfield, I will hear from you. But the jurisdictional issue seems to be pretty strong, Ms. Felder Gates.
Well, I think that there are some misconceptions in his motion, Your Honor. We did have a hearing, and the hearing was scheduled within, I think, a timely fashion. It was in front of Judge Wright Hill. We presented the entirety of our evidence as plaintiff. Unfortunately, Mr. Butterfield began his cross-examination, and I had objections to his evidence as being admitted, and the court decided to reschedule for a second part of that hearing. So it's my position that we had a hearing, Your Honor. It was scheduled in a timely fashion. We just did not get to presume the hearing from at the standpoint that we were in.
And I'm going to just ask questions as sort of devil's advocate as we go along. So please don't take that I've made up my mind as to this issue. Did any party object to the continuance?
Not sure, Your Honor. I'm not sure if I objected to it or not. I believe that it was one of those things where the court was saying, hey, here's what's going to happen. So whether you objected or not, I don't believe a party objected, but I can't be sure. So, okay. But I will present the motion, Judge, and I'll be quick with it because it's pretty much going to be what I have in my motion, if you would like for me to do so.
Well, I've read the motion, and the issue that comes to mind is the point that was raised by Attorney Felder Gates as to whether the hearing was started within the 30-day period, but wasn't concluded. Well, and that's why I was asking about whether there is any objections.
Right. I got two things, Judge. So if I may. So for her response, because she kind of start arguing the motion. So first, Judge, if you look at paragraph 6 of my motion under OCGA 19-13-3, it says, first and foremost, a hearing shall be held within 30 days from the filing. Okay. No later than 30 days after the filing of the petition, a hearing shall be held. In this particular case, Judge, as I stated, this petition was filed on it was filed on February the 16th. Well, the first hearing wasn't held until March the 18th. So the first thing I raised in my motion is the court held it outside of 30 days from the beginning. So the court never had jurisdiction. But even assuming somehow you assume that the court did have jurisdiction after that, let's talk about the hearing. The hearing that was held, as I state in my motion, the plaintiff got a chance to present their case. I didn't get a chance to thoroughly and fully cross-examine the petitioner at the time because the court stopped it and said, basically, look, we're not going to have a chance to do this today, or for whatever reason, the court said, we're not going to have a chance to do this today. And a new hearing was scheduled for the 31st of March. Again, this was on March 18th. On the 31st, I contacted Ms. Moultrie, asking for the link, and I think opposing counsel asked for a link. And then we were basically, no hearing took place. Don't know why no hearing took place. We never got a written order at all. I do believe the court may have been aware that a divorce had been filed. Maybe the court felt, okay, y'all can handle all that in a divorce. It's a superior court. But this issue has been handled before. I cited the case, Judge of White versus Raines, 331 Georgia Appeals 853. It is a 2015 case, and the exact thing happened. It says the trial court's order continuing an ex parte TPO against an ex-husband was reversed because the trial court lacked authority to extend the TPO since the court failed to comply with the requirements of 1913(3)(c) in any substantive way, because the court in that case questioned the wife briefly, but then the ex-wife was not sworn as a witness and the husband did not have an opportunity to cross-examine the wife. Well, that's what happened in our case. Miss Attorney Felder Gates put her client up and put on direct evidence. That's just in white. The court put the asked questions of the wife. We never got a chance to do a cross, and both cases were continued in that case. And the court right there said that's error because they didn't comply with the statute. In this particular case, it also says a judicial emergency does not alter the requirements. I cited the case of Smith versus Smith. So I did an analysis there. So basically, Judge, the initial hearing wasn't held within 30 days. So consequently, the court didn't have jurisdiction from the outset. See White versus Raines. Nevertheless, even when the hearing was set, the court continued with sua sponte. Ms. Mack's attorney Felder Gates, had an opportunity to put her client up, but there was no cross. And in this particular case, Mr. Mack never agreed to a continuance, nor did he agree to have the case linger on indefinitely. In this particular case, the petitioner never came forward. Here we are a year later, a whole year later. Even if the TPO was granted, it would have expired by now. But I filed the motion, in December, but because of the case law. So it's absolutely clear. We got, at the time I cited my motion, there were 247 days that passed. I guess we can add December, January, 60 more days. I mean, it's a whole year. So I think the law is clear, Judge, and we're asking that, this case be dismissed for want of prosecution or failure to comply with the code requirements. So that is what we have, Judge, in this particular matter.
Okay, thank you. Ms. Felder.
And now let me say one more other thing.
Mr. Butterfield, you
case,
said you're going to be brief.
Oh yeah, real quick, Judge. Let me put my camera back on you. Second thing is the petitioner, Ms. Mack, lives in California. Part of the divorce that's going on, she moved in October. My client has never contacted his wife since February, Judge. He was out of his home. He got back in because she moved out. We agreed he can go back to the home, but this woman lives in California. So that's just another reason why the court should go ahead and dismiss this. So that's all I have at this point, Judge. I think the law is clear.
And Mr. Butterfield, I would ask you not to respond to Ms. Mack as this woman. She's either a respondent or Ms. Mack.
Oh yes, that's fine,
this
Judge.
woman,
I'm sorry.
this woman lives in California.
Yes,
I'm asking you
that's
to
fine,
refer
Judge.
to her. Okay.
I will do
Okay.
that, Judge. No, I'm not a disrespectful person, but I was simply saying that's fine.
Ms. Felder Gates, what's your response to Mr. Butterfield's initial argument that the first hearing was held outside of the 30-day period?
Well, Your Honor, there was no objection. There was not this motion was not filed until after we proceeded with the hearing. So there was no objection at that time, and he consented to proceeding with the hearing at that time. And so I believe he's trying to now use this at his advantage. But I think your question was very valid in that was there an objection to the continuance at all? And was there an objection to proceeding in the case if it was 2 days out of time? So, Your Honor, I believe also that the case that he's citing, it's much different than ours in that the court even went in so far to analyze what they proceeded with in front of the trial court before deciding to continue the case. There, the trial court said that they only questioned the party briefly. The party was not sworn in as a witness, and the opposing party didn't have an opportunity to cross-examine her. He had an opportunity to cross-examine my client. However, the judge was very clear in that we needed to speed things along. However, Mr. Butterfield on that day had just given me exhibits, and the court wanted to know if I had objections to his exhibits, which I did. And so the court instead said, well, we're just going to continue this because if we're going to take it exhibit by exhibit, we're going to need additional time. That's essentially what happened. My client had been sworn in. My client presented all of the facts in her testimony. And that means we had quite a bit of formality to proceed, despite Mr. Butterfield not being able to present his evidence on cross-examination, which tended to be his focus. And like I said, Your Honor, I just reiterate the fact that he did not object at that time. I believe he consented to the hearing, and now to say it should be dismissed because it was out of time is an issue that he cannot now proceed on, having consented to a proceeding within the time frame that it did. And so, Your Honor, I would still want to proceed with the hearing on the preponderance of evidence that there has been an act of criminal violence. And we made every opportunity to get this heard, Your Honor. And so the audacity of Mr. Butterfield to contend that no one has done anything in all this time. I have tried to get hearings in the divorce. I've tried to get hearings in this case. I just could not get a hearing for the life of me. But I've done all that I can. And to this end, Your Honor, I am still asking for her to be afforded the opportunity to speak on this allegation. The parties do still need to stay away from each other. Mr. Mack has gone in so far as to review every single last video on the ring recording, as she did tend to reside. So I believe it's necessary. And I still believe that there could be some imminent threat and it needs to be addressed.
So Ms. Felder Gates, there is a divorce pending, correct?
Correct, Your Honor.
Before what judge?
Judge Mason.
And what's the case number? Do you have the case number?
Case number is 2021 DR 00654.
0065. You said 654?
4. Yes, Your Honor.
Okay. So how far along is that case? And I don't mean age, I mean by pleadings, any depositions, in exchange of documents?
It's I believe it's ready for trial. It's been prolonged long enough, but we have already done a motion for final hearing. We're just waiting on a trial date.
Is there a reason these matters can't be heard before Judge Mason?
I would be okay with that. It's just that I do not want to take the risk of there not being, because the reality is I do believe that a protective order is necessary, or some order of restraint is necessary. And I just want to make sure that she has the protection she needs pending that action. It's because that's all we really saw. As a matter of fact, he did speak. I can't remember if it was Miss Moultrie, and I don't want to say it was incorrectly, but I do remember there being a call to my office requesting that this be heard by Judge Mason. But as I followed up via email about that, we never got this heard in front of Judge Mason. And we've done temporary motions for fees and amongst other things, but neither here nor there. We haven't gotten a hearing in front of Judge Mason. And I just don't want to put this off any further and then have it be dismissed.
Was there a temporary order put in place for?
No, Your Honor.
So there's no order from Judge Mason as it relates to these parties and how they're to conduct themselves during the pendency of this divorce here?
No, Your Honor, there is not.
Did you request one?
We got
Several times, Your Honor.
Well, Judge, if I may speak now, Judge, two things. One, in my divorce petition, we cite the law that during the pendency of divorce, the parties won't harass or molest each other, and we wanted that followed. So and they answered that. So there's been no contact. And just like Attorney Felder Gates is here on to advocate, to be an advocate for her client, let me tell you about Mr. Mack. My client's never been in trouble, Judge. For her to say that she's concerned about them having contact or anything, it's nothing there other than these allegations. My client has submitted to and passed a polygraph, which Ms. Felder Gates has.
Your Honor. Please do not allude to this polygraph anymore.
No, hold on. All right. Right now, I'm trying to deal with jurisdictional issue. As far as I'm concerned, Mr. Mack and Miss Mack are both angels under the grace of God. So I don't need to hear anything about them. We're dealing with the jurisdictional issue.
Well, Judge, to be fair, if she's going to say that she believes a protective order is needed, I'm responding to what she said, Judge. But quite honestly, if she's able to suggest to a court that she has belief that my client poses a threat, I'm bringing you evidence to suggest he is not a threat, Judge. That's all I'm doing. She had I didn't interrupt her at all. I do believe I have a chance to advocate on behalf of my client, because if I don't, he's going to call me on the phone probably and say, hey man, why you let that lady say all that stuff about me? So that's all I'm doing, Judge. So bottom line,
Mr.
Judge.
Butterfield, hold on, Mr. Butterfield. I'm not convinced, Ms. Felder Gates has not convinced me that the jurisdictional issue is moot. Okay, so that's what I'm saying. I don't want to, if I'm going to dismiss this on the jurisdictional issue, I don't need to hear about all of that kind of stuff. And just like I admonished you about Ms. Mack, Ms. Felder Gates, as far as I'm concerned, Mr. Mack, as he stands here, the petitioner has the burden of proving anything. And so I've washed, just so both sides know, I wash all of that stuff out. I'm not concerned about that because there's a divorce pending. So obviously there's been some bad blood. Obviously people don't like each other. So I'm not here to address that issue. Ms. Felder Gates, and I'm sorry for cutting you off, Mr. Butterfield, but I'm gonna give Ms. Felder Gates one last time to convince me that the jurisdictional issue is not a viable claim.
Your Honor, at this juncture, again, all I can reiterate is that there was no objection to proceeding on the TPO on the date of March, the specific date. Pull that file back up.
March 18th, Ms. Felder Gates.
Yes, Your Honor. So there was no objection at the time of proceeding on the previous hearing, Your Honor. We did proceed on substantive issues at that time, and there was no objection to continuing the hearing. And it is my request to continue upon the hearing to determine the merits of the case, Your Honor. I do not believe it.
My understanding of the state of the law is that if a court doesn't have jurisdiction, the court can't gain jurisdiction. Meaning there's a murder case and the case gets transferred to state court. Judge can't say, well, nobody objected to the murder case being held in state court, so I just went ahead and adjudicated the matter. As I understand the way the statute is written, I agree with Mr. Butterfield that there's no action that needs to be taken on behalf of the respondent if the case isn't heard within 30 days.
Well, Your Honor, the statute also says that in the event a hearing cannot be scheduled within the county where a case is pending within that 30-day period, same shall be scheduled and heard in another county if that's the case. And I'm not really sure as to why the delay was had, but I would certainly say, Your Honor, that we've made every attempt to have this case heard, and the case should not be dismissed based upon 913.3, Your Honor.
Let me ask you this question. Why is it so important for this matter to be heard in this proceeding when there is another proceeding that theoretically encompasses all of this? Because hold on.
Sorry, Your Honor.
If Mr. Mack committed the allegations that are alleged in this protective order, wouldn't that go to Judge Mason making a determination as to the dissolution of the marriage, disposition of property, whether there should be a continuing protective order put in place as a part of a settlement agreement? I don't understand why people keep trying to parcel everything out instead of dealing with it in one hearing or one setting.
I would love to, Your Honor, and that was my original intent. It's just that this case has been delayed so much, and I'm not putting the blame on anyone in Judge Mason's courtroom, but it seems so deliberate at this point, and I have no other option but to pursue whatever opportunity I can so that the facts and evidence and the merits of these allegations be heard at some point. Because if the ex parte order is just simply dismissed, we have nothing for her to stand on to ensure that there's no further contact.
How about under the divorce number that there's a consent entered into by both parties that they will not contact, harass, or intimidate each other during the pendency of the proceeding, that your client has not given up on any of the allegations that have been contained in this protective order, and that she will seek to have a protective order put in place as a part of the settlement agreement.
I would love to pursue that, Your Honor, but see, violation of a standing order does not automatically subject you to a criminal violation to the full extent of 2 years and minimum imprisonment. So I believe the consequences are different if it's a violation of a protective order versus a violation of a standing order, which is only a contempt hearing, which I can't even get a motion for interim fees hearing. So if I can't get a temporary hearing on something that was filed back in April, I just don't foresee her any protection on any other mutual consent order or standing order in the divorce court, Your Honor.
That's
And
why
so
I
I'm
asked, that's why, hold on, Mr. Butterfield. That's why I asked for it to be a consent. Because there's nothing for Judge Mason to do except sign the consent agreement. You don't even have to come to court.
But the issue, Your Honor, again, is still on a consent order. The consequence is contempt power, which is another motion. Now, if they're willing to consent that a warrant for arrest be issued in violation of that.
No. See, Ms. Felder-Gates, you're complicating things, and you're making me worried about the statement that you said about contempt versus criminal. It sounds in my ears that you're trying to maneuver Mr. Mack into being arrested.
No, Your Honor, I'm trying to ensure that there are secure consequences that will not be delayed. Because in the civil context, as already demonstrated, it's very simple to delay getting a hearing in front of a judge versus someone being arrested.
That's why I addressed that through a consent agreement.
And
let me put it in this way. Both Ms. Mack and Mr. Mack, their lives are in Judge Mason's hands. And if they were to do anything wrong or improper, Judge Mason can issue orders that will be very punitive to either one of them. I'm just, as a judge, because I see it so often, especially in family law situations where there's a divorce file and people go get a TPO, or there's something else out there and people go get a TPO. And unfortunately, what I'm hearing a lot of times, the lawyers are advising the clients to go try to get a TPO instead of addressing the matter in one courtroom before one judge, so that everything can be handled at one time. And we're not in a situation where, like, I don't know what has happened with Judge Mason, but I've taken the representation of both of you as lawyers as to what has taken place. The consent agreement, as it relates to harassing or intimidating behavior, contact, all of that. If Mr. Butterfield and Mr. Mack are willing to consent to that, and your client, because as I heard the argument was your client is concerned about her safety, this would address her safety the same way if we had the hearing and I issued just another piece of paper. Because the piece of paper is neither a sword nor is a shield. It's a piece of paper that directs the parties to act in a certain way. So if he's going to violate the TPO, he's going to violate the consent judgment. The consent agreement. Does that make sense to you?
Sure, Your Honor, but I just find it very pleasant to be in front of you, Your Honor, but yet in front of Judge Mason, it's very difficult. And so I'm just not willing to simply consent to it being dismissed. I do understand, Your Honor, if you feel the court does not have jurisdiction to address the matter, I would just ask for an order that just simply reflects same. And the merits would still be preserved anyway, at least the claims of the criminal violence in front of Judge Mason. So I do understand that, Your Honor, but I'm just not simply going to consent to the dismissal of this protective order hearing, because this is the first opportunity I've had to even try to get anything substantive in front of a judge in Clayton County.
I understand. Okay, this is what I'm going to do. I'm going to ask for Mr. Butterfield to prepare a proposed consent agreement, placing the language in place as it relates to as if I had issued this protective order. So there's no contact outside of court. There's no harassing or intimidating behavior, either by Mr. Mack or Ms. Mack or by third parties. There's no attempt to contact third parties to reach out to another person. If there's any communication that needs to be had, it'll go between Mr. Butterfield and Ms. Felder Gates. And if you prepare that, I may even, if Judge Mason, he has allowed me to hear matters before. And just so you understand, Ms. Felder Gates, I think Judge Mason has over 250 murder cases on his calendar that are backed up because of the pandemic. So I understand what you're trying to do as it relates to your client, and I appreciate that. And I'm trying to accommodate that as best I can. But I do believe the jurisdictional issue is valid. But I'm also asking for this to take place because the consent agreement to take place, because it provides everybody with a reasonable amount of reassurance that this matter is just not being taken care of. So, Mr. Butterfield, do you believe that you can draft something and have it to Ms. Felder Gates by tomorrow?
I do believe so, but we're talking, and I just want to make sure we're clear, Judge. On this particular TPO, the court is based on the law, the court will dismiss this, just, based on lack of jurisdiction. And then in the divorce case, you want me to draft a consent agreement saying neither party shall, and it's not an admission of guilt on anything relating to the TPO, but it'll be a consent order and it'll say neither party shall harass, et cetera, et cetera. I'm fine with doing that in the divorce case, but this case will be dismissed without it mentioning any kind of consent language, right?
And you
So
may, yes, sir. And you may even add a line in here that as it relates to this TPO, the parties agreed that it was not fully litigated and these matters are not subject to res judicata. She can bring it up in a divorce case, which she could have done anyway.
You talking in the consent agreement? Because your order dismissing this will simply be this matter, a hearing was heard and based on the evidence in the law, the court is dismissing this matter for what jurisdictional reason or whatever. But then under consent, you can add that line about res judicata. That's fine. Right.
And Ms. Felder Gates, if you run across case law where you believe I'm wrong, please send a copy to Ms. Mary and Mr. Butterfield of a case that shows that I'm wrong.
Your Honor, I would have been glad to do this before today, but even though Mr. Butterfield and I have had discussions about a consent mutual order to stay away and to this effect, it wasn't done. And so that's what brings us here today, Your Honor, yet another communication of a document that wasn't procured. Instead, he filed a motion to dismiss this case. And so it's very clear that he just wanted to ensure that this case be dismissed and not decided on the merits, which is fine. But I just want to make sure that the claims have not been adjudicated and that they would be presented anyway in front of Judge Mason. That's it. And I want to make sure that she's protected and that he doesn't continue to attempt to make these contacts with her or her friends, family, the like. So I don't have any problem consenting to an order to that effect. I would have done that before today.
And not to go back and forth.
No, I was going to say you both are strong litigators, and I see you trying to protect your client's interests, and I have no problem with that. That's why I'm trying to fashion a result that would allow everybody to at least walk away from this part, understanding that you still have the divorce to be litigated, understanding that there are protections in place as to either party, if either party were to violate the terms of the consent agreement, and that should be sufficient.
Thank you, Your Honor. I appreciate the feedback.
Okay. All right. So Mr.
Can I
Butterfield,
ask a question?
yes, ma'am.
So is the consent agreement going to be filed under the divorce number or the?
It's
or
gonna be filed under the divorce number, because if it's a consent agreement, Judge Mason doesn't have to do anything, but sign off on it. And it should be to Judge Mason's attention.
No
Okay,
problem, Judge.
Okay,
all
so
right.
they're going
All
to
right.
send it directly to Judge Mason's judicial assistant?
Well,
Or
I
do you want
wanna-
me to still facilitate it? It's fine.
Yeah, I do, because I don't want there to be a situation where there's a disagreement, and then it's now floating out in the ether. As I
Okay.
understand from Mr. Butterfield and Attorney Felder Gates, that they're both willing to enter into this agreement. I've known Mr. Butterfield since I was in law school, and I'm just meeting Ms. Felder Gates. So I know I can trust Mr. Butterfield and Ms. Felder Gates. You've been straightforward, so I believe I can trust you. I keep putting these people in the waiting room and they keep coming back on. So is there anything else that needs to be addressed?
Not from the respondent, Your Honor. Thank you for hearing from us today, Judge, and I hope you have a good rest of the day, sir.
Okay.
And
Ms.
I
Felder
will
Gates?
get that email over to you as soon as possible.
Okay. Ms. Felder Gates?
No, nothing further, Your Honor.
And just so you know, again, the reason that I want to take a look at it is because if there's going to be any disagreement, I want that to be resolved tomorrow. I don't want there to be, now it's 6 months later and we're arguing over what the term is means. So I just want to get this matter resolved. Both litigants have a right to have their matters handled in an efficient and quick manner. So thank you both for your attention, and have a good day.
All right, thank you, Judge.
Okay.
Judge, before you let anybody in. So on this.
Hold on, let me
TPO
stop. Let me stop the
Okay.
recording.